Good morning, everybody. Welcome to the District of Columbia Court of Appeals. We have three arguments on this morning's calendar. We'll first hear argument in 24 CV 300, Little versus District of Columbia, and counsel for petitioner or appellant in that case is appearing remotely. Mr. Boscolo? Mr. Boscolo, you are on mute.
I apologize, Your Honor. May it please the court, Benjamin Boscolo for Elizabeth Littell. I'd like to reserve 5 minutes for rebuttal.
Go ahead.
Thank you very much. This is a case in which no one believed they were responsible to maintain the pavers in front of 810 7th Street because the District of Columbia government did not follow its own policy concerning the execution of covenants of maintenance between the District of Columbia, who owns the property, including the sidewalks, and the landlord to the office building at which the non-standard pavers were in front of. This is, I think, a case of first impression on this particular regulation, but not really a case of first impression in the District of Columbia. DCMR 24-1105.9 talks about a variation in the District of Columbia's responsibility for maintaining its public sidewalks when non-standard paving materials are used. There is no dispute that non-standard paving materials were used here.
Counsel, your argument seems to then suggest that you would almost accept that a contractual agreement, the covenant, if there had been one here, could serve to shift liability. So, I mean, that seems to be an odd concession. I know it's not a concession because your argument is that there was no covenant here, but go ahead.
It's not a concession. It's similar to the Texaco case, where in the event there was such a contract, the district could then file a counterclaim, a cross-claim, a separate action for contribution or indemnity to the extent that the contractual agreement between them and P Street required them to maintain the pavers. That wasn't done here. I don't think anything, I think taking care of the public sidewalks is a non-delegable duty. And if we look at, and I hope that answered your question, Your Honor, I'm not saying that I could have sued the lessee directly. I'm saying that in the event that the District of Columbia was found liable, this covenant of maintenance would allow them to seek either indemnification or contribution from the person with whom they entered into the contractual agreement. And I think that's very similar, and I'm going to get these backwards. I think that is the Texaco case, in which the Texaco station used a big part of the sidewalk as an entry and an exit to the gas station parking lot. The District of Columbia was held liable, and they were then allowed to make a claim.
So you don't think you could have, sorry, you don't think you could have also sued the property owner in addition to suing the district here?
I don't think I could in good faith, because prior to instituting litigation, I hired an investigator. We ascertained that there was no responsibility on the property tenant's part to maintain the sidewalk in front of the property. And during the litigation, we got an affidavit to that extent, which is part of the record. The affidavit is at page.
I mean, part of my reaction, Mr. Boscolo, is who cares? Who cares if you could have sued the property owner? But I mean, it's also an affidavit from that property owner saying I'm not liable for it is hardly dispositive of the issue. You know, I think it's uncontested that they were allowed to use non-standard pavers. They built it underneath the regulation. They were responsible for maintaining it. I mean, I don't see why. I don't understand your answer as to why you couldn't have sued that property owner as well.
I don't think there's any common law responsibility against them for maintenance of that sidewalk, because they had no duty to maintain that sidewalk. And I don't think there's any evidence in this record that allows the court to find that the tenant had a responsibility to take over the non-delegable duty.
Well, they had a regulatory duty to maintain the sidewalk. And so your argument is, I mean, I think it's not precisely that they had no duty to maintain the sidewalk. It's that the regulatory duty could not by itself override common law or statutory principles of liability. Is that accurate?
Yeah, so since I'm not representing the tenant, from Ms. Littell's point of view, that is her point of view, is that there's no common law duty that was overridden by this regulation. And if you look at the snow and ice cases, they are not exactly on point, but they are certainly analogous. The Alberti case that we cited in our brief, I think is an even stronger case than this one to suggest that the district does not have an obligation to take care of its sidewalks.
Well,
because-
there's a separate statute there that
Correct.
is in effect in those cases, right, where the district has deliberately taken on that duty as opposed to attempting to deliberately disclaim that duty here.
No, in Alberti, they there was a legislative enactment by which they passed on the responsibility to the landlord. And in that case, the fall victim sued the landlord directly and not the District of Columbia. And the court found that, and there's some pretty strong language in there, saying that the sidewalks in the District of Columbia are publicly owned and therefore controlled exclusively by the municipal authorities in the district. And it's therefore primarily the duty of local government to keep its sidewalks reasonably safe. Now it says the words at the end of that sentence are after a snowfall. I don't think it's any different when in that case, the defect was snow. In this case, the defect is a lip. And the Liberty case goes on to cite McGuire versus the District of Columbia and said it described the legislation as an attempt on the part of the municipality to shift to the shoulders of individual citizens, which this landlord is, the burden which is primarily incumbent on itself. And that was a legislative enactment, not a regulatory enactment. And the thing that legislative enactment has in common with the regulatory enactment here is there is no private right of action for Ms. Littell under either the legislation in snow and ice removal or this regulation in the event of a fall on a lip on a sidewalk. And so the absence of the right to bring a private cause of action based on that regulation absolutely precludes Miss Littell, I think, from bringing a claim.
Help me again with that, because that's one of the things that just confuses me, why there could be no private right of action. I mean, you concede that it wasn't the district that put those pavers in place, right?
It was not the district. There's no evidence that the districts put those pavers in place. There's no evidence that the landlord put those pavers in place. But I have no evidence to suggest the district put those non-standard paving materials on the sidewalk.
But if the landlord did, they assume some responsibility, right? Even in the absence of this regulation.
I don't think so. I don't think they have any responsibility to maintain the public sidewalk. This is not a private sidewalk. If it were a private sidewalk to their building, I think that's a different situation. But this is a public sidewalk.
So if they had their non-standard building material were trapdoors, and what they trapdoors with spikes at the bottom of them. And, pedestrians walk by and the district says, you can do what you want out in front of them. They built that. You would say no liability for them because it's not their sidewalk.
I would say no liability and negligence, Your Honor. I would say negligent.
Okay.
I would say intentional tort, assault, battery. I mean, that's a pretty extreme example, and I understand.
Okay, so it's a slip and slide. So it's just really slippery material that doesn't have any traction to it. I mean, it seems a little. I don't really well, I mean, I don't want to get bogged down in it because I don't know why you're fighting it. Why are you fighting the second defendant? Maybe you can sue both. I mean, Texaco was an indemnification case. A lot of these cases are indemnification cases. So I don't know what it gets you to say we couldn't have sued the adjacent property owner.
Okay, so I think what it gets me is that the court's entire grant of summary judgment in this case was that the regulation exonerated the district from its non-delegable duty to keep the sidewalk safe. That's why I may be misfocused on whether or not the tenant has some responsibility, because it seems to me that's what the order from the trial court suggested, and I don't think that's accurate. And as I think you appropriately said, who cares? I think they can both be liable, and the question is whether or not that regulation removes the duty of the District of Columbia to maintain its public streets. And I don't think that regulation exonerates them from negligence. And that's really the only issue that the court based its order on here.
Can we talk about, I mean, we have a whole notice issue here, and there are different factors that go to both actual and constructive notice, but can we talk precisely about the role of the regulation vis-a-vis notice? So once the district passed the duty to maintain on to the private property owner, how does that play into their ability to have actual or constructive notice of the defect? If in essence, they've farmed out the responsibility to check for defects to the property owner.
So if you look at the appendix at page 62 in the deposition of one of the designated representatives, and it's the testimony around there, the district, when there's a report of a problem on the sidewalks, which there was in this case, there was a report nearly a year before of these defective sidewalks. What the representative of the District of Columbia said is, we have an obligation to inspect that sidewalk, including non-standard paving materials. And
The report, if I'm not mistaken, was basically the entirety of Chinatown and the Penn Quarter, right?
no, it was the block in front. It included the block, specifically the
But it
affidavit.
definitely included the block. I mean, you can make a complaint saying the district's sidewalks are in shambles, and that would include the block. But if I'm not mistaken, I think it was going from K Street all the way down to the mall on 7th. I mean, I don't know, 7 blocks?
Yeah, it surprisingly sounded not unlike the block range described in that regulation for the
So-
specific pavers.
The affidavit is at page 341 of volume 1 of the district's affidavit. And it says specifically, it references the sidewalk at 810 7th Street. And this witness, Jennifer Smith, says, I made a complaint to the city of Washington, D.C. in 2017 requesting sidewalk repair via the DC 311 portal. And so the 311 portal is an electronic form, right? Where a person is given options about what to fill in. And it does say what the court says it says. But this is a very factual question about whether or not that notice to the government and the way the government accepts reports of requests for service puts them on notice of this problem at 810 7th Street, which is exactly where it occurred, is a question of fact for the court. But we're putting the court before the horse. A year passes and no inspection of any kind is made in response to this 311 complaint. Had any inspection been made, these pavers would have been.
Well, I mean, we don't know that because we don't know that this defect existed when the 311 alert, I would call it a call, but it wasn't a call. Let's just call it a call. When the 311 call was made, we don't know that this defect even existed, right? We have no date for that. Well, I mean, I guess it was 2017, but we don't,
17, and the defect is about pavers popping up in the affidavit. And so this is, I think these are specifically factual questions which make that issue, the issue of notice, constructive or actual, not one of law for the trial court. And the trial court didn't reach that. And I understand it's before you, and you could find that even if on issue 1 there was error, it was harmless if there's no notice. There is certainly more than adequate evidence to submit the question of whether or not the district was on notice of this defect in an adequate amount of time to change it. But Judge Shanker, I want to finish your question, which was how does this whole covenant of maintenance play into the notice issue? Because it does. Because the 311 reports, even if there's a covenant of maintenance, still goes to the District of Columbia. The District of Columbia performs an inspection, and in the event they're non-standard paving materials being used, they then notify the tenant, and the tenant has 30 days to remedy that. And so that's how this all works with notice. No citizen in the District of Columbia would know who to report, which tenants get reports of problems on the sidewalk. It goes to the Department of the District of Columbia Department of Transportation, I think. And so there is a connection between the covenant of maintenance and inspection and notice. But I think that the district recognizes, right? The district recognizes that this regulation 1105.9 does not remove their responsibility to care for the sidewalks, to maintain, be sure they're in safe walking position. And that's the whole point of having the covenant of maintenance. And the covenant of maintenance is described in the deposition of one of the corporate representatives at A70 of the record. And it talks specifically about, it's a document that's binding to the property to maintain material in a public space, usually non-standard materials, right?
It
And
also describes that it's not something they do in every instance, though I think we'd all agree that it would be best practice to do so. Well, what do you have that shows us that this is something that's as mandatory as you seem to suggest?
Well, I don't think it's mandatory. I think that the policy of the District of Columbia to have, so I guess the answer to that question would be probably one which won't win me any points with this panel, but it's common sense, right? This is like the Three Stooges. The District of Columbia says we're not responsible to maintain this space. The building owner says we're not responsible to maintain this place. And they both point their fingers at one another. And the district uses a regulation of which the building owner is not aware. Maybe they should be, maybe they shouldn't be. Maybe that will be the basis of an indemnification claim against the district. But as Judge Deal said, who cares? This goes to whether or not that regulation removes the obligation from the District of Columbia to maintain its sidewalks. That's the net effect of the court's order. And the fact that they have this whole policy in place that they try to maintain in every place, and I'm not casting aspersions at any person, it didn't get done here, shows that they recognize that their tenants don't understand their responsibilities to maintain the sidewalk in front of the street. And in this case, in this particular case, at very best, there's a joint responsibility, right? And the joint responsibility is because there are both standard and non-standard paving materials on this sidewalk in front of the building. And so maybe had an inspection been done and the district had told the tenant to fix the non-standard paving materials, everything,
Okay.
including
Okay.
the bricks. Then the second thing I'll say, I'm sorry, Your Honor.
I think it should be the last thing you say, unless my colleagues have any questions. We've taken you over your time.
All right, then that's the last thing I'll say, and I'll wait for any other chances you give me to speak in rebuttal. Thank you.
Thank you, Mr. Bosco. We're racing against some snow here in person, so I wouldn't mind getting people out of the courthouse before that hits. So we'll hear from the district. We'll still give you a few minutes in rebuttal.
Thank you, Your Honor.
Thank you, Your Honors, and may it please the court, Mark Rucci on behalf of the District of Columbia. There are several ways this court can affirm the judgment of the Superior Court and rule in favor of the district. In the district's view, notice is the easiest and most judicially efficient way to resolve this case. Assuming that the district owed Ms. Littell a duty of care with respect to the maintenance of non-standard paving materials in front of the subject property, Ms. Littell has failed to proffer evidence that the district had actual or constructive notice of the hazard at issue. In order to resolve this particular dispute, the court need only look at 3 documents in the supplemental appendix. That's Ms. Smith's 311 report, Ms. Smith's affidavit, and the photographs of the pavers at issue in October 2017 and October 2018. There's no need to issue a new rule of law. This can be a fact-bound application of established precedent when it comes to constructive and actual notice. I'll start first with actual notice and look directly to Ms. Smith's 311 report, which was filed on October 19th, 2017, nearly 1 year before the subject accident. That's available at Supplemental Appendix 86. It lacks meaningful specificity and focused on the condition of red bricks across 6 district blocks in the downtown streetscape area from I Street all the way down to the National Mall. The actual affidavit says the brick sidewalks from 7th and I are in disrepair, or in horrible disrepair. The bricks are unstable, there are missing bricks, and some of the bricks are much higher than others. There is no dispute in the record that Ms. Littell did not trip on a red brick. She tripped on a granite paver. That is undisputed by Ms. Littell herself and as well by the record. When asked to select a type of material in the 311 request, Ms. Littell or Ms. Smith chose brick red, and that's available at Supplemental Appendix 87. There
So, I
was
mean,
no-
let's say that this defect existed at the time that that call was made, and that it wasn't de minimis, as you argue in a separate argument. If that 311 alert put the district, to some duty to inspect the area, and this defect had been noticeable, then, I mean, is it your position that the fact that the notice referenced brick would have allowed the district to say, I see this, but I'm just gonna keep going because she didn't mention brick? I mean, she didn't mention granite, sorry.
Assuming that it is the district's responsibility to repair non-standard paving materials, which we do contest.
Right, that's separate. I'm talking
and-
about notice.
And assuming that the actual paver at issue here was defective in October 2017, which to your question earlier to my colleague, we would dispute that as well. There's no evidence in the record that the actual paver on which Ms. Littell injured herself was defective in October 2017. And we know that.
No, I thought Miss Smith's affidavit says that she tripped specifically in front of that property. Now, granted, she doesn't identify the specific paver, but I thought she says her 2017 complaint was in relation to herself tripping over the same set of pavers in front of the same property. Or at least that was my reading of her affidavit. So one could say, you know, there's at least a year there where these pavers in front of this property had been a problem for somebody, if somebody credited Miss Smith and what she says in her affidavit. Why isn't that enough to say there was some evidence in the record that for a year these pavers had been sort of in disrepair?
So Judge Deal, if you look directly at the affidavit of Ms. Smith, which is available at Supplemental Appendix 239, when she says she tripped on granite pavers in front of 810 7th Street Northwest, she does not provide a time frame for that affirmation. That could have occurred after the accident. It could have occurred before the accident. There's no context in which she said she actually tripped on those granite pavers, let alone that it was the exact same hazard that Ms. Littell herself tripped at. So that affidavit lacks any meaningful specificity.
I agree it's not so specific, but I mean, it's very short, right? And she says only a few things. She says she's tripped on those specific pavers. She made a request for repairs in 2017. And a year later, if the district had done what it should have, Ms. Little wouldn't have tripped in that exact same spot. I mean, to me, putting two and two together, she seems to be saying, or at least should have an opportunity to clarify that, yeah, that's the spot that I tripped back in 2017. I mean, it just kind of is the most natural reading of her affidavit.
Well, Your Honor, I do believe it is Ms. Littell's burden to show by a preponderance of the evidence that there is sufficient evidence for a jury to resolve. Putting that aside, however, it's not clear that what Ms. Smith tripped on occurred before her 311 submission actually went in. So to link those two things together, that she tripped, then submitted the 311 submission, therefore the district was on notice, there's no evidence in the record to support that. These are two disparate pieces of information. And I'll go back earlier to my point to Judge Schenker. The 311 report only references red bricks.
Right, and I guess, so that's what I was asking. I'm asking you to assume that the defect in the paver existed at the time and the district, put aside whether the district had a responsibility to actually correct the defect, but if they had gone out to inspect the brick and this defect had been noticeable, do you agree that even though she didn't mention granite, that would have put the district on sufficient notice? That they should have seen it, in other words.
Assuming that the defect was not de minimis and that it was a significant defect that required repair and that it was the district's responsibility and it was the exact same paver and the district was aware of it, I think that would get Ms. Littell to actual notice. I do not think that is the evidence in the record here, Your Honor. That would be building, assumption upon assumption upon assumption. And this court has repeatedly said that we cannot let juries engage in sheer guesswork when it comes to deciding whether or not an individual had actual or constructive notice as to a particular hazard. It is Ms. Littell's burden to show that the district had actual notice, which we believe is the higher burden here.
So counsel, can you talk to us about why, even if that 311 call was quite vague, why a 6-block radius was just too much to possibly go inspect?
Your Honor, I think it lacks meaningful specificity for the district to go out and repair 6 blocks based on a 311 report that talks about a type of
Well,
standard
we're not
paving.
talking about repair. I'm asking to go look at 6 blocks.
There's no evidence in the record whether the district remediated or effectuated any type of inspection within a timely manner. I know the district has about 270 days normally in their best practices to go out and investigate and try to attempt to repair depending on the level of severity. What I will say is that this court has previously said in a case called Abbin versus District of Columbia, which is cited in Lynn in both parties' briefs, that a mere snow report, a weather report that it snowed over a 3-day period was not sufficient to show that the district was on actual or constructive notice that on a particular day within that 3-day period, there was a icy hazard that caused a particular injury. So there's a 3-day window. The plaintiff is attempting to say something occurred within that 3-day window that injured me. That's the only evidence I have is that broad range. We would posit that the 6-block radius describing a different type of paving material without any sufficient contours as to time is just like the case in Abbin, where it's insufficient to actually create a genuine dispute of material fact for a jury to attempt to resolve. And Judge Schenker, what I wanted to say earlier to your question, sidewalk defects can materialize all in an instant, or they can materialize slowly over time. So even if the condition of the granite pavers or the red bricks was in horrible disrepair in October of 2017, it's not clear that it was in horrible disrepair at the time of Miss Little's accident 12 months later. And so this defect could have materialized the day before, the week before, the month before, not necessarily 12 months before when the affidavit goes in.
I'm not following that. So they could have been in disrepair in 2017. But that wouldn't provide evidence that they were also in disrepair in 2018, despite any lack of evidence of actual repairs?
No, Your Honor, just a friendly amendment. Despite Ms. Smith saying there was disrepair in the general area at that time, there's no evidence that this particular paver was in disrepair. It could have become defective within a very short time frame before Ms. Littell's injury. And that's just the nature of sidewalk defects. They can occur.
I mean, really, I mean, that's your argument? Like, if the evidence were this, Ms. Smith calls DC 311 in 2017 and says, right in front of 810 7th Street, the pavers are a mess. They pop up, you touch it, and I tripped on one and I hurt myself. You guys need to do something about it. A year later, somebody trips, Ms. Littell trips and hurts herself. Would you be before us saying we don't know if it was the same brick that was in disrepair the year before? Is that the level of notice you need with that degree of specificity?
No, I don't think so, Your Honor. I would say that in that instance, there's both a direct address that is being tied to, not a broad range of a particular area. You also specified in your hypothetical a particular type of material, which is the material that Ms. Littell alleges here was defective. And the fact that it was not repaired in 1 year, I think would probably, in terms of either actual or constructive notice, maybe say the district should have been able to repair that, assuming it was their responsibility to repair it in the first instance.
What about, let's just say I read Ms. Smith's affidavit to be saying, this is where I tripped in front of 810 back in 2017. That's what prompted my call. If they had addressed my call within a reasonable amount of time, Ms. Littell wouldn't have tripped. Why is it that you think, so if it had been an open, forget about her 311 call. I agree with you. That is, it describes a broad area. I don't care so much about red brick. I mean, I look at these pavers, some of them look reddish at times. So I don't know if we expect people to say brick versus pavers. But I can agree with you that she describes a broad area. It's not pointing him right to the spot. But what about just it being, why couldn't a jury conclude this was open and obvious? If it had been there for a year, there had been no repairs for a year, that would be enough for constructive notice for the district.
Because in your Honor's hypothetical, you're reading in it had been there for a year. In Ms. Smith's affidavit, it doesn't say it had been there for a year.
No, I'm not reading it in. I'm asking you to accept the premise that's how I read her affidavit. I mean, her affidavit says, it doesn't say, this is the date I tripped in front of 810, but it does say, in 2017, I made these 311 reports. I tripped in front of 810. She doesn't identify any other reason why she would have called 311 back then. And then they didn't act. And if they had, they would have fixed that area. I think the best inference from reading all that is in 810 is where I tripped.
Your Honor, if I understand the hypothetical correctly,
I don't really mean it as a hypothetical. I'm just asking you to quit fighting the premise that Smith's affidavit, what she's saying in those very brief sentences, what she says is I've also tripped in front of 810. I made a 311 call in 2017 asking for repairs. If they had done the repairs, Ms. Littell never would have fallen. I'm saying you take those three things together and the most natural inference is, 810 is where she tripped in 2017 and that's what prompted her 311 call.
Your Honor, I would just dispute that
Okay, I get that you disagree, but let's go to the next part. Now, other than calling it a hypothetical, if you accept my premise, why wouldn't that be constructive notice for the district?
I think at that point, there may be enough for the district to have known that a particular defect existed at a particular location. If Ms. Smith said, I tripped at this location, I made the district aware in a more specific, non-generalized way.
No. Now you're talking about actual notice. I want to talk about constructive notice. What about and it was there for a year? In fact, here are the facts. Ms. Smith trips over pavers in front of 810. She calls and leaves this opaque, somewhere in Chinatown, there's a sidewalk that's in disrepair. But that thing that somebody could trip over is out in the open for a year. I'm just wondering if that is enough for constructive notice.
It is not, Your Honor.
Okay.
Constructive notice is a totality of the circumstances inquiry, which looks at both the length of the time the defect existed, whether or not it was obvious or latent, and its severity. So assuming that the defect existed for 1 year, the severity here, Ms. Littell, in her own opposition to the motion for summary judgment in the record below at supplemental appendix 146, 149, 160, and 161, describes the defect as latent, not obvious. So that cuts against her and in favor of the district there. In Briscoe, this court relied on a plaintiff's declaration that when a plaintiff described a particular defect as latent, not obvious, that cuts in favor of non-constructive notice. As to the severity of the defect, Littell's own expert explained that the defect was only about 1/2 inch, and that's at supplemental appendix 94 with a photograph at 136. In Briscoe, the court explained that minor sidewalk defects are something that are all over the place, not something that need to be remediated, and they particularly described 1/4 inch to 1/2 inch defects, which is exactly what we have here. So even assuming under constructive notice, a totality of the circumstances inquiry, we still think the fact that assuming as true that the district was aware for 1 year, which we would dispute, that would still cut in favor of the district. And Judge Deal, if I could just convince you attempt to convince you one more time with record evidence that we think disputes the fact that this existed for 1 whole year.
Sure.
Before the actual accident.
The picture of the month before?
The photographs, the
Sure.
district's photographs. So if you turn to the district's photographs, which are available in October in 2017, there are photographs of the exact subject pavers. Those are at supplemental appendix 121. Those show no defects in the pavers in the exact same month that Ms. Smith submits her 311 report. And, to your Honor's question, Ms. Smith said the entire area, 6-block area, is in horrible disrepair. If you look at those pavers, they are not in horrible disrepair at that time. They're
not the best pictures, but I mean, in that they're taken from some distance. It is tough. It is tough to scrutinize very closely, but I think it's a fair description that they appear to be in pretty good repair at that time.
And I think we have more, Your Honor. So then you go a year later to the same 3 weeks before Ms. Littell's accident. That's supplemental appendix 123. Again, the pavers are not in horrible disrepair in that photograph, but we have even more. If you look in the record at supplemental appendix 431, the property owner here regularly tasked their engineers with inspecting and maintaining the non-standard paving material in front of the building. They would have weekly or bi-weekly reports for their engineers, and they would ask the specific question about whether the property's, quote, sidewalks, pavers, and building entrances are in good condition, including free of walking hazards. This is something the property understood was its responsibility. And we have in the record from January 3rd, February 13th, March 15th, March 21st, May 10th, all are examples where there was a defective paver and the actual building, the private property owner repaired the paver in-house, not letting the district know. And we also have a report on October 25th, which is 3 weeks before the accident, that where an inspector of the building says yes to the question of whether the property's sidewalk, pavers, and building entrances are in good repair. So we know at that time, the routine maintenance of the property owner here was checking for these types of defects and did not find any defects. And it is their common practice when they find a defect, they remediate that and then they document it. All of the record evidence points in the opposite direction to Ms. Smith's 311 report that the area was in horrible disrepair. She may have been talking about red bricks, and that may be true, but that is not the claim that Ms. Littell has decided to bring today. We do think that this is the easiest way for the court to resolve this case because Ms. Littell has already shown that she's willing to brief this argument on appeal and take this. If the court were to remand on the regulation or on the de minimis argument, we think we'd be right back here in the exact same place if the Superior Court granted our motion for summary judgment on notice. And in order to conserve judicial resources, we think the court should just resolve the case on those grounds.
Unless my colleagues have any further questions. Thank you, counsel.
Thank you.
And Mr. Boscolo, we'll give you a few minutes for rebuttal.
Thank you, Your Honor. I only have a couple of points recognizing the weather conditions. The first is there is a report to the District of Columbia of the sidewalk being in disrepair. By their own policy, they have 270 days to do something about it. 365 days pass and they do nothing. Secondly, we are here on a motion for summary judgment, and any inferences that can be drawn have to be drawn in favor of Ms. Littell. At no point did the district take the deposition of Ms. Smith to identify the exact paver, and I think the self-serving reports of the landlord are something that a fact finder has to determine whether or not Ms. Smith, a person who was walking on the sidewalks, and she specifically talks about seeing people fall on the pavers in 2017. And so this is not a wishful proposition on the part of Ms. Littell. And so
She saw other people fall across the street at 819, right?
she talked about the pavers in front popping up when you stepped on them at that point and witnessing someone. Again, we're getting into the weeds that I don't think matters. This is a question of fact. This is not a question of law. This is not what the trial court passed on. The trial court passed on the regulation, and there's really been no argument about it. And I think what should happen here is Ms. Littell should get her day in court, and we should let a finder of fact resolve factual disputes. And if the trial record is as strong as the District of Columbia thinks it's going to be, Ms. Littell, of course, disagrees with that. There are other remedies they have, but this is not a summary judgment case. And for that reason, we ask you to send it back and to allow Ms. Littell to make her case to a jury of citizens of the District of Columbia. Thank you.
So just to be clear, at best on the affidavit and from our 311 caller, this is evidence of something being open and notorious. And so, perhaps open and notorious is not the language to show, but there was something there that could be seen as opposed to evidence that there was some actual form of notice.
No, I think this is actual notice. And I think that when the District of Columbia went out there and you hear the testimony of Ms. Smith, she's going to talk about these pavers in front of this building. But that being said,
But the only place where there could have been actual notice, right, was not the affidavit, but the 311 report.
Correct.
And so the affidavit only goes to trying to say that, and not saying that it doesn't succeed or anything, taking no stance on that, that there was something she saw specifically there that if they would have gone, they would have seen.
That's a fair statement, Your Honor.
Okay.
Okay, unless there are any further questions.
Thank you very
Thank you,
much.
counsel.
I appreciate the court allowing me to appear remotely. Thank you.
We will take the case under consideration.
May be excused.
We'll now call the second case this morning, Family Federation versus Moon, number 23 CV 836. Waiting for, there it goes. There's your time. All right, counsel, whenever you're ready.
Thank you, Your Honor. May it please the court, Kathy Hanger on behalf of the plaintiffs, and I'd like to reserve 3 minutes for rebuttal, please. In Moon 3, this court rejected the defendant's request to dismiss all remaining claims for 2 reasons. One, because the trial court had not decided whether an exception to the fraud inclusion exception to religious abstention exists and may apply in this case. And because the subpart of breach of fiduciary duty alleging that the defendants acted in a scheme of self-dealing had not been adjudicated. But on remand, neither of those things happened. We didn't have a trial on self-dealing, and the trial court did not decide whether the exception exists. Instead, the trial court erroneously applied prudential standing considerations to dismiss Preston Moon from this case and our claims against him with prejudice, and misapplied the doctrine of prudential standing so that it could justify the dismissal with prejudice. The trial court also misconstrued the Moon 3 decision as eviscerating the KIF transaction from the case, which is not what it did, so that it could justify finding that there was no longer an extraordinary measure at issue for Hooker factor number 2. And then the court at every turn refused to decide whether the exception exists. And the result is no remedy for these church plaintiffs. The result is a dangerous abstention precedent where we have DC nonprofit directors who are acting in a secular capacity through a process that was mired in deception and secrecy and following no corporate norms, transferred substantially all of the assets of a DC nonprofit corporation, $3 billion worth, into a secret Swiss pass-through. And they said that they did this for secular reasons, taxes and financing, which the trial court below found not credible. And we know it's not credible because the evidence showed also that after making that transfer, these assets went all over the world to obscure layers of opaque offshore entities in Anguilla, the Caymans, Labuan.
Can I?
The result.
I mean, the difficulty with the claims in this case, as we tried to elucidate in Moon 3, kind of comes down to the simple question of what if Reverend Moon had done it? So let's say Reverend Moon during his lifetime made these same transactions. What would your argument, would you think that you could bring, your clients could bring a fraud claim against him?
Reverend Moon was not on the board of the DC nonprofit.
I know he didn't do it.
So I would say the issue is that the transfers became a vehicle to essentially launder the DC nonprofit assets of all the protections and guardrails of DC nonprofit law, including the prohibitions on a DC nonprofit director dispersing assets in a way that would personally benefit
I
them.
would still just kind of like to have an answer to my question, though. What if the facts were that Reverend Moon were on the board of UCI, that he gave the same donation to KIF? I think what we said in Moon 3 is the problem with these claims is it's basically conceded that Reverend Moon could do that as the head of the church. You know, the only condition of these donations has sort of been, you know, Reverend Moon will do what he thinks best for the church and for the movement. And so we said, well, the abstention problem comes into play because now we have a succession fight about who the proper head of the church is. And if Reverend Moon could do it, well, then his successor could surely do it. And if it's conceded that Reverend Moon could do it, then in order to sort of scrutinize the veracity of your claims about whether or not this was fraud would require us to say yay or nay as to whether or not Dr. Moon is the proper successor. And so that same problem arises when I hear you describing all these transactions as being problematic, which is why I say, what if Reverend Moon had done it?
Well, I would first say that Reverend Moon was never a director of a DC nonprofit corporation with a secular duty to fiduciary duties to the group. If Preston Moon wanted to have the UCI make these donations to benefit his GPF foundation, to benefit his personal pursuits, he should have resigned from the board.
Well, okay, so I mean, well, I don't want to stop your answer to Judge Steele, but I mean, that's the crux of your argument, right? Is that these were self-interested transactions, self-dealing transactions, the transfers to GPF and KIF. But I don't see the allegations that those were self-dealing, and I don't see the summary judgment evidence that those were self-dealing. You may call them in, you know, Preston Moon's general interest or his desired movements of these funds. but where's the self-dealing?
Well, the problem is we never had a trial on self-dealing.
Well, but no, I mean, it's not a trial issue. It's a pleading issue and it's a summary judgment issue. And if you never alleged or presented summary judgment evidence of self-dealing with respect to those transactions, then that goes to the heart of the standing question, right?
Well, I think this is where the trial court got it wrong. I mean, we are here on a 12B1 motion, a 12C motion, and a factless summary judgment motion. So we shouldn't even be really looking at these issues about whether or not Preston Moon was the leader or not, or the leadership dispute. We're really here on these procedural issues. And to answer your question on whether KIF was in the case, this is the trial court's ruling defies this court's finding in Miller McGee versus Washington Hospital Center, where this court found that it was fundamentally unfair to assume that a theory that developed in discovery was not in the case, when there was a prior ruling of the trial court that said, I recognize that this new theory, this informed consent theory, is not explicitly in your complaint, but I'm going to read it into the case because everybody knew about it. And then later that same court said, no, I changed my mind. You should have amended. I'm going to dismiss with prejudice. The Miller McGee case said that's wrong. And that's exactly what happened to
Okay,
us here.
but even after discovery at the summary judgment stage, on remand, what was the summary judgment level evidence of actual self-dealing, and which we've defined generally as a party being on both sides of the transaction? So it's not just whether Preston Moon had an interest, some, nefarious interest or ulterior motive to have this money moved to GPF and KIF, but whether he was on both sides of that transaction. And I don't know what there is that you have to support that.
At summary judgment, there was, the trial court found there were disputed issues of fact on two transactions that we should have had a trial on. In addition, on summary judgment, the defendants excluded excluded their religious abstention doctrine from their motion, excluded self-dealing from their motion for summary judgment on the religious abstention doctrine, recognizing that self-dealing would not be subject to religious abstention, because you can never, as a DC nonprofit corporation director, use the funds to line your own pockets or for your personal pursuits. And so that issue was never adjudicated. The case proceeded below on the duty of loyalty theory, affirmatively on summary judgment. So the contract claims and the self-dealing claims got tabled. But just like the KIF transaction, the gift transactions came into the proceedings and the summary judgment proceedings on the first theory of breach of fiduciary duty of loyalty, it makes no sense for the KIF and the gift transactions not to also have been read into the remaining parts of count 2 for breach of fiduciary duty. And that's where the trial court really got it wrong here on a procedural issue.
So counsel, to draw you back in towards Judge Deal's question though, if we're going to determine kind of any of that, we have to find some basis for the entity's purpose and what it should have been doing. And that's not just in those bylaws, but in how the entities acted before. And so how do we draw that out from the ecclesiastical question?
So I think you recognize the exception and find that it exists in this case, because your Judge Deal raised the issue of hierarchical deference. Well, at the beginning of the case, at the time when these transfers happened in 2010, Reverend Moon was alive and he was the hierarchical leader of the Unification Church of the Family Federation. There was no dispute at that time that Reverend Moon was the leader of the church. And so we have now Preston Moon coming into the litigation, and in the Askew case, the Third Circuit recognized in the Askew case that making decisions during litigation to insulate questionable actions from civil review under abstention in and of itself may give rise to the bad faith that would apply the exception. But in Moon 3, this court already found that the Supreme Court strongly suggests that the exception exists. And there must be a limiting principle. Otherwise, you can have what's happening here. You can have a director of a DC nonprofit take $3 billion worth of assets, claim that he's the fourth Adam, and this court can't touch it. No court can touch it. And how many fourth Adams are we going to have marching into DC Superior Court claiming messianic?
That's not just his claim. That's Reverend Moon's description of him in the early 90s.
Well, that's never been adjudicated, and that's not accurate. And
I don't think it's disputed, so far as I can understand.
So if we had a fraud and collusion, if we had an evidentiary proceeding on fraud and collusion, what we would have been able to do is demonstrate in two ways that the exception applies. First, the exception applies, there's really two avenues, and you recognize this in Moon 3. It applies where a religious entity or figurehead acts in bad faith for secular purposes. That's already been established by the remedies order and Judge Cordero's order over a dozen times.
That was vacated. I mean,
Well,
that order was vacated.
the relief was vacated, but courts rely on facts that were found in vacated orders all the time.
No,
There's plenty of.
the underlying premise, counsel, of it being bad faith was that they had some obligation to serve the Family Federation, something that we then said we can't say because of the abstention doctrine. I mean, that was, it's only bad faith if good faith required service, acting in service of Family Federation. And that was the position that your client took in the last appeal. That this is the institutional embodiment of the movement. Acting outside the movement's wishes constitutes bad faith. We said, we can't say that your client is the institutional embodiment of the movement. There is a schism. Who is the proper successor is not for the courts to determine. And then as to it being secular, we also said, well, gee, here's a list of a dozen things of secular interests, often that Reverend Moon was directly affiliated with himself that he would often donate to. So the fact that the donations are going to a secular cause are just part and parcel with the entire movement. That's what UCI has been doing from its inception, donating to the Universal Ballet, the Washington Examiner, I think Bridgeport University, we list off, a firearms manufacturer, some anti-communist causes, just a whole bunch of secular things. So to me, when you say it's bad faith, it keeps coming back to true, if not being used to advance unification purposes. But in order to say that requires some religious determination that don't really have the capacity to make.
I disagree.
Okay.
It doesn't require religious determination to determine whether Preston Moon and the director defendants use these assets to pursue their personal pursuits. If we had a fraud inclusion evidentiary proceeding, and I see my time is up, may I complete the answer?
Yes, of course. But just to pinpoint one question is, again, this kind of brings me back to my initial question, which is a lot of Reverend Moon's projects were personal pursuits. I think you could fairly describe them as. I think some could, I don't mean this pejoratively, but some could describe them as vanity projects. Projects to raise the profile of the church and, in the way that religious leaders often do. So to say that it was, they were raising their personal profile, if you have a claim to being messianic in a church, raising your profile seems kind of part and parcel with, raising the profile of the church. No?
So the prior donations are not at issue on the narrow issues that are before this court, which is really the standing, whether the exception exists or not. And the exception exists, it must exist, otherwise there's no limiting principle. And this court essentially already found that we made a prima facie showing of fraud and collusion. So once in Moon 3, you said that we made a showing what amounts to a claim of fraud and collusion. So once you read, it's not a big leap to take the marginal review. Presbyterian Church then says you undertake the marginal review with a fraud and collusion. So there's two avenues that we were deprived of, which is number one, bad faith acts for secular purposes. And that gets in, there's tons of non-religious secular acts that were found to be mounted, and the trial court found, when taken as a whole, the director's actions demonstrate they did not act in good faith when they approved the donations to Kith and Gift. And that's based on conduct, not theology, conduct, excluding the general counsel from the meetings on Kith, tricking board members into resigning.
I think it's based on the view that we set aside that their obligations were to the Family Federation, that's what the unification church that they were acting in service of meant. And we said, no, court. I take your point that there are some factual findings that I guess our last ruling might not have totally disturbed, but that sounds like one that we definitely disturbed. When they say, they were acting in bad faith, I think what the trial court meant in that since vacated order is they were not acting to further the interests of the Family Federation as the institutional embodiment of the unification church. And we said, no. You, trial court, cannot say the Family Federation is the institutional embodiment of the unification church without getting into an ecclesiastical question And so that undermines the whole notion of bad faith. Does that, I mean, does that make sense?
I'm gonna disagree because
Sure.
what Judge
I mean,
Anderson
you should-
said, and this is at JA 2403, she concluded, it appears that the money donated to KIF is simply being funneled to the defendants and their personal own projects, and that's self-dealing. And DC nonprofit directors are not supposed to disperse the assets of a nonprofit in a way that enriches themselves and their own personal pursuits. And that's the problem. They're wearing these secular hats as DC nonprofit directors, and they're using the assets to enrich themselves. It's a totally different theory we didn't get to adjudicate below because we didn't have the trial on self-dealing. And the standing rulings really are at the linchpin, because at a minimum, we should have had a dismissal without prejudice, because under the UMC development case, which this court found that a standing ruling is going to be a dismissal without prejudice, because if you dismiss with prejudice, it's a merits decision that's in conflict with finding that you don't have the jurisdiction because there's no standing. And the defendants know this because one of the defense counsel won in that case, and the defendants cited that case in the first opening part of their motion to dismiss on remand for standing. So the dismissal, if at all, should have been without prejudice. And at a minimum, as this court did in the UMC development case, we should order that the trial court change the dismissal, because then we could amend the complaint to tell everybody what they already know, even though we shouldn't have to under the Miller-McGee case. But I do want to just briefly address the schism issue. The facts of the schism have never been adjudicated. The only way to adjudicate them is to undertake the marginal review that we should have in a fraud and collusion evidentiary proceeding, which we were deprived of. And in that kind of proceeding, we would be debunking the veracity and the sincerity of this fourth Adam narrative and this leadership dispute. So for example, if we had a fraud and collusion evidentiary proceeding, we would show that this fourth Adam status is like in the Askew case being used during litigation to insulate questionable church decisions. So the evidence would show, we would show in a fraud and collusion evidentiary proceeding that Reverend Moon's statements in 1998 that Preston Moon relies on to claim that he is the fourth Adam, those statements actually show that he said, quote, he has a course to go to establish the foundation of the fourth Adam. The evidence would show in a fraud and collusion proceeding that Reverend Moon's statements reflect that the fourth Adam is not an individualized person or
How
Preston
does that
Moon
not
himself.
get us into doctrine?
Because this would, I'm only talking about what it would look like to undertake marginal review. Because the problem is he didn't raise the fourth Adam flag until 2019 in this litigation when he started losing. He raised it in response to the plaintiff's motion for remedies. And at that time he said, I don't have enough religious abstention infused into this case. I'm going to pump it up. And so he started raising this fourth Adam flag, and this court should look behind to take marginal review of the veracity of it, because it's the same thing with the leadership narrative. If you look at his 2008 report to parents, in that report to parents, he's criticizing Reverend Moon for running the church as a church rather than doing it the way he wants, which is an ecumenical, non-denominational, modern movement. And why would you ask somebody, and then he begs his father in the report to parents to put him in charge of everything, and Reverend Moon didn't.
This doesn't sound very marginal to me. We're chest deep in a lot of facts and allegations, which you may potentially be able to prove if we ever got there, but my head's already swimming on ecclesiastical questions about what Dr. Moon wanted and the direction of the church. And it just doesn't sound very marginal. I'm not sure what the definition of marginal review is, to be honest, but it doesn't sound like this.
Well, I don't think it has to go that far. But because they're raising it, I do want to address that there is a disputed story there. And why would you ask somebody to put you in charge of everything if they weren't the one that's in charge? So there is misrepresentations being made and elaborated on this court that should be looked at on marginal review. But again, on the fraud and collusion exception, there's two avenues. You don't necessarily have to look at the smoke screen. What I'm talking about is the smokescreen avenue, but the first avenue is the religious figures acting in bad faith for secular purposes. And I think you can already find on the findings on the Judge Anderson opinion on secular issues. I mean, secular facts that were found. I mean, she found that removing directors and demoting the general counsel after they challenged Preston Moon for engaging in self-dealing, replacing the directors with unqualified people who approved the KIF transfer without any evaluations, no appraisal, no opinions from an attorney, whether they're brief breaching their fiduciary duties. And then they approve the KIF transfer before KIF even exists. I mean, these are extraordinary facts. This is the type of fact pattern that the court and the Supreme Court said in the Thomas case is so bizarre as not to be entitled to protection under the free exercise clause. That's why
What makes
this is the
those
case.
individuals unqualified?
I'm sorry?
What makes those individuals unqualified in your view?
Well, there was evidence in the record, I think that Judge Anderson cited about them not looking at documents, not understanding what they were, having no idea what the KIF transaction was about.
Okay.
Things like
That's
that.
fair. I wanted to ferret out, was that doctrinally based or not? Thank you.
No, that's what I'm saying. There's tons of secular facts in the remedies order that support the ultimate conclusion that they did not act in good faith when they approved the KIF donations. And then again, I think the key is that the reasons that they said that they did the KIF transaction was not religiously motivated. They said they did it for tax reasons and for financing reasons. Those are totally secular reasons. They have nothing to do with religion or theology. And Judge Anderson found those excuses were not credible, and we know they're not credible because they then sprayed the assets all over the world. They sold one of them for $1 billion immediately, and none of the directors, none of the defendants know what happened with that money. But we do know from discovery, and this would have been part of a fraud inclusion evidentiary hearing, and it would have been part of a self-dealing, is that these assets got dispersed to offshore entities, and they were compounded by other actions of self-dealing. I mean, the Yan Sant loans, where Preston Moon is loaning $500,000 to a close associate, Yan Sant, and then he gets paid back by UCI in the amount of $1 million, $500,000 right in his pocket. And this has a bit of a stink to it. This is the case to find the exception exists and applies.
Thank you, counsel.
Thank you.
We will hear from counsel for appellees. Mr. Schaefer, if you can specify how you and Mr. Roth are splitting your time, if you are.
Thank you, Judge Gill. Yes, we are splitting time evenly. I want to make sure that I'm not intruding upon Mr. Roth's time for the individual defendants. I will be arguing on behalf of UCI. Thank you, Judge Gill, and may it please the court. Your Honors, we're here in 2025, obviously, for a case that began in 2011. So we're 14 years in at this point. And this litigation has taxed the courts, it has taxed the parties, it has taxed a religious movement to no end. This court came very close to ending all of this in Moon 3. Our respectful submission, our modest submission, is that nothing is materially different this time around. And I will not go heavy on this, Your Honors, but when there's discussion of bad faith, I do have to note that the one apt use of that is the continuation of this litigation by the plaintiffs and their new counsel after prior counsel withdrew in the wake of Moon 3 and their unsuccessful rehearing petition, recognizing that what remained of plaintiff's case was totally foreclosed as a matter of law, not as a matter of holding, Judge Deal. It's not that technically before this court last time around were the exact same claims. There was a difference in terms of procedural posture, but in terms of what this court held substantively based upon the First Amendment and ecclesiastical abstention, the case was over. And the lawyers who were representing the plaintiffs at that time knew it. We sought sanctions. And I think the one thing that was questionable in Judge Irving's decision, even as he said the motion for sanctions was well taken, is that he mercifully spared plaintiffs and their lawyers from those sanctions. We could be here appealing it. I'm not. I'm out to end the litigation. We'll let it go, Your Honors. But if there was any substantial question posed for this court, it would have been that.
So,
Sorry.
would you agree that if the GPF and KIF transactions had fallen under the self-dealing umbrella, that they would still be live without a standing issue when it went back to the trial court?
Judge Shanker, two answers to that. Okay. The first is when I say that certain things were not before this court last time around in Moon 3, I don't mean that to refer to the KIF and GPF transactions. The same arguments that you just heard Ms. Hinger making about those transactions and why they were supposedly out of bounds were the same arguments that this court heard in Moon 3 in the briefing and in the argument, the same critique of them. So
And I think this question is more towards your co-counsel, so I apologize for that, but
no problem.
Okay.
But Judge Shanker, let me make the second point, which is, as Your Honor was referring to self-dealing in your question to Ms. Hinger, the KIF and GPF transactions do not answer to that description. They simply do not. There is no allegation, there could not be a good faith allegation that Dr. Moon or any of the other individual defendants was on the opposite side of that transaction. I think Judge Deal has it right. When we're talking about a messianic evangelical movement, as is true here, of course, there's a vision to be realized, and there's an effort to advance the mission of the movement. And Dr. Moon and others are gratified to see that the KIF donation is translating to the development of Park One in Korea, the holiest of land, and this massively successful economic development. That's the culmination of Reverend Moon's vision. Of course, they wanted that, but not because they were personally enriching themselves through that transaction. So I think to call that self-dealing is not only, it's either disingenuous or totally hollow. There's no self-dealing in that transaction. When Ms. Hinger critiques it as supposedly not being the sort of donation that UCI should have made, it's the same critique that was before this court last time.
Now, I think one of her arguments is any responsible board with this amount of money or trust would have exercised some oversight and attached some strings to a donation of that size. As I recall, there was a donation agreement, but more or less, once that asset left UCI's coffers and went into KIFs, UCI sort of lacked any oversight ability over it. And I think your opposing counsel is saying, that raises a huge red flag. What's your reaction to that?
Several answers, Judge Hill. The first is the question that you asked, that you will not get a straight answer from Ms. Hinger on because she's not authorized to provide it. If Reverend Moon had specifically blessed the KIF donation, you will not hear from Ms. Hinger on behalf of her clients that they would not have been perfectly fine with it. It would have been irreproachable. So it all comes down to, any dispute comes down to what Your Honor identified last time, pages 69 and 70 of Moon 3, footnote 28. If they're faulting any of these donations, including as to KIF and GPF, it's on the premise that this is a hierarchical movement, which is very much contested, and that Reverend Moon is the one who controls it, which is also contested. It comes down to the succession dispute. As Your Honor said, the succession dispute comes to the foreground at that point. That's my first answer to it. But number two, donations to the University of Bridgeport, the Washington Times, Martial Arts Academies, the ballet, none of those, Judge Deal, had strings on them. None of those had continuing oversight by the movement. Those were donations that were made in good faith in furtherance of the movement. No different than for KIF. And I have to note,
I mean, all those institutions, I think have some sort of pre-existing ethos and, operating plan. Like I think I could figure out what the Universal Ballet does before I donate a bunch of money to them. I think I could figure out what Bridgeport University does before I donate a bunch of money to them. Whereas KIF is a new creation. I think if I'm not, tell me if I'm wrong, but my recollection is established solely to take control of this asset, making the lack of any, it's not just continuing what it's always been doing, you can trust it to do that. It's sort of being created to do a thing that UCI seems to exercise no control over. And that does seem quite different.
I don't think it is, Judge Deal, but let me also note, KIF may have been new. The people who were entrusted as the directors of KIF were old, trusted members of the movement who had been identified for that exact reason. You had best-in-class advisors, legal advisors, and financial advisors who were determining what were the best practices surrounding the KIF donation, and that's what was followed. Ms. Hinger faults the directors for not having themselves paid more individual attention to it, Judge Howard, but it's because they were relying upon external advisors who've been retained for that purpose. And Judge Deal, if you might ever be troubled in any case about the hypothetical of what if this was done with nefarious purposes and without good faith and so on, let me just note that KIF went on to do exactly what Reverend Moon had taught was the ultimate goal of the movement, which is to develop the holiest of land in Korea in a very successful, flourishing sort of way. And that is the pride of the movement, is Park One. That is the direct product of the KIF donation. So I think that there are all sorts of assurances in the way that this was done from the ground up, even if this wasn't subject to the ecclesiastical abstention doctrine as it is. But then we also have the reality that is incontestable, that KIF went on to do exactly what loyal, devoted members of the movement should want to have seen it doing. But that's exactly what was before the court last time around. I think this court got it right in Moon 3. There was a reason why there was no vote calling for rehearing, and there was no grant of rehearing. And so what you had on remand was simply an effort to slap new labels on the same basic theories that had been rejected. And as this court taught in Moon 3, following the teachings of the US Supreme Court, the labels don't matter. The fact that you call this a claim under count 2 as opposed to count 4 doesn't make any difference. For First Amendment purposes, it's no less intruding upon contested religious questions that the courts cannot decide.
I mean, would you agree if there had been a written contract that expressly forbade these types of transactions, that we might be outside of a religious abstention area?
If it could be adjudicated according to neutral principles, Judge Shanker, then it would be like the Steiner case that this court decided. It would be like the Michelle case that this court decided. If you have neutral principles that courts can enforce, of course that's different.
Right, and whether you can apply neutral principles depends in part on whether there's a written contract, right? At least in part.
That's true. All I mean to say, Judge Shanker, is if the written contract had said only only the truest teachings of the unification movement can be followed, or the true successor to Reverend Moon is the only one who can authorize the donations. I can't imagine written contracts that would run into the same problems that the articles do, in that any enforcement of them calls for intruding upon contested religious questions. And so I think it suffices to note, as Your Honor is suggesting with the question, there's no written contract here. And everything you have from the plaintiffs as to what is the contractual constraint, it comes down to the Articles of Incorporation that Your Honors decided last time around could not be adjudicated consistent with the First Amendment. And they speak when they say that there were contractual commitments. They speak in terms of the purposes and the mission, and in fact, the articles of UCI. And I'd point Your Honors to page 819 of the record, which is where plaintiffs answered the interrogatory question, what is it that you say is the contractual constraint? And essentially they say missions, purposes, articles, and then they cite a lot of testimony and record fragments for the proposition that that's what UCJ was donating according to, the missions, purposes, and the articles. That runs right down the same path and smack into the same First Amendment wall that this court was speaking in terms of when it came to Moon 3. And if Your Honors want to grapple with the fraud exception, and I don't think you need to go that far here, it's not applicable to the claims, it's not preserved, but we don't think the fraud exception in fact exists. If Your Honors had to go that far, that's exactly what our friends to the other side, and I use that term in the sense of counsel, but they argued it successfully to the SDNY and said there was no fraud exception, and that's what they convinced the Southern District of New York and the Second Circuit of. The last argument they have here is that there should be a reopening of discovery, which is the last thing that this court should want to see happen. Judge Irving was well within his discretion as he analyzed 11 factors to explain why there shouldn't be reopening of discovery at this late stage of the litigation after there's been a mass of discovery in years prior. If Your Honors have no further questions for me, I'll turn it over to Mr. Roth.
Thank you, counsel. Mr. Roth?
May it please the court, Yaakov Roth on behalf of the individual defendants. Your Honors, many litigants accuse their adversaries of misrepresenting the facts or the law, and we certainly maintain that plaintiffs have done their fair share of both, but this court can actually resolve this appeal as to the individual defendants solely by correcting the plaintiff's mischaracterization of the procedural history of the case. The only claim against the individual defendants that survived Moon 3 was what this court called the self-dealing subpart of count 2. So the question is, what was that? And the court admitted it didn't really know because it hadn't been briefed. It wasn't before the court, which is true. But if we go through the history of the litigation, it's actually quite clear what that subpart was and what it was not. And importantly, it never included the donations to GPF or to KIF or to anyone else, nor could it have. And that is dispositive because the plaintiffs admit on appeal that without KIF as part of this remaining piece, there is no extraordinary measure that is sufficient for special interest standing.
So you say nor could it have. Can you explain that? piece of
Yeah.
your answer, piece of your argument.
So there are 2 points. One is that was never, for a decade of litigation, they had a self-dealing claim that never included the donations. And what I'd like to do after, with the court's permission, is just tick through some of the key documents that show that, so that the court can trace it through the litigation and see that to be the case. Now, the reason it was never, those donations were never framed up as self-dealing is because there was never any evidence of the directors being on the other side of those donations. There was full discovery into these donations, including extensive discovery into KIF in particular. And there was nothing that was ever turned up to show that the defendants benefited personally from those donations. In fact, even in the remedies order that the plaintiffs like to cite, the trial judge admitted there was no personal benefit to the directors from these donations. That's at JA 2432 for findings to that effect. Her concern was, well, they advanced the Dr. Moon's personal agenda. That is certainly true in the sense that he, as the fourth Adam and the leader of the unification movement, had certain things he wanted to accomplish, charitable purposes, and the donations furthered that agenda.
So, I mean, you know, as a judge up here, you know, your colleague on the other side says that discovery presented some evidence of the individual defendants lining their own pockets through these transactions. I don't know whether that's true or not. I haven't dug through all of the discovery. The argument is, at that point, we should have been able to amend the complaint, and then these KIF and GPF transactions would fall under self-dealing, thereby standing, et cetera, et cetera. So what's the answer to that?
So first, I would urge the court to look at what the plaintiffs cite when they make those statements. Because if it was there in the record, there would be a citation for it. It's not there. And I can assure the court that if you follow the citations they provide, you will not find any evidence of that in the record. They didn't give it to the court below when we raised these motions to dismiss on remand. They didn't put it in their brief on appeal to this court. It's because it doesn't exist. And that should be sufficient. In terms of amending, if they had some basis to amend, and they could have said, these are the facts we would add, and here's some basis for it, and maybe Judge Irving would have allowed it, although I still think it would have been about a decade too late at the time they tried to bring this up. They knew about these transactions as early as 2012, and yet for a decade of litigation, they never tried to describe them as self-dealing until Moon 3 and after Moon 3, when their primary theory was blown up as barred by the First Amendment, and then they decided to say, well, actually, maybe we can squeeze it all back in under the label of self-dealing, but there was no basis for that. So what I'd like to do, just if I could, is just give the court the relevant record citations, first for the proposition that this was never their theory. Okay, because that I think is actually the first place to start, is what did they claim was self-dealing? And if we look back, what the court will see is there were always two distinct theories. Duty of obedience, which is you gave donations to entities that are unaffiliated with the church, didn't advance the true purposes of the corporation. That covered GPF and later KIF. And then there was a separate theory, duty of loyalty, where they identified particular corporate transactions that UCI, or actually for the most part its subsidiaries, had engaged in business transactions. And they said that the counterparties to those transactions were owned by Dr. Moon personally. Those were called the self-dealing claims, or also the related party transaction claims, but they never included the donations. So just point the court first to the complaint, JA 198. There's a separate subheading that alleges self-dealing, and it identifies, this is paragraphs 48 to 52 of the complaint, specifically, uses the word specifically, and that identifies the transactions that it alleged to be self-dealing. When we first moved for abstention on the pleadings, the plaintiff said, no, our claims can be resolved without getting into religious questions, and they pointed to the self-dealing claims, and they cited those particular paragraphs of the complaint, 48 to 52. That's at JA 416. When that issue came up to this court in Moon 1.
I mean, it seems, counsel, like you whittled down what we described as a potential fraud or collusion exception, which could certainly one flavor of fraud can be self-dealing, but it's not the only one. So I mean, I take your point. If you want to walk me through the record further, you can. But you know, I take your point that they had discrete self-dealing claims that did not include the KIF transfer. But it doesn't seem to totally answer the question of, but when they describe the KIF transfer, were they describing something akin to a fraud that, you know, they had a different theory before, but now that that's gone, interpreted generously, they've kind of always been saying, what's going on here is somebody is acting with church, like funds that were donated to advance a religious cause, for a totally secular and purpose that's divorced from that movement altogether, and that is a flavor of fraud. So I mean, I mean, you might want to address
Well, here's how.
something broader than just self-dealing, because I take your self-dealing point, but I think that might be
I'm-
too narrow of a view of it.
Absolutely, Your Honor. I'm addressing self-dealing because the way I understand Moon 3, the court said, number one, you have this amendment theory, that's non-justiciable. Number two, you have this theory that donations didn't advance the real purposes of the corporation. That's not justiciable. Can we dismiss count 2 altogether? No, there's this wrinkle because you have this other theory, self-dealing. We don't know exactly what that is, but it might be, that one might be justiciable, including because it might satisfy this exception if it exists. And so remanded to deal with that self-dealing claim. So that's why I'm talking about self-dealing, because that's the only other claim that was remaining after Moon 3.
I'm not sure we were that focused.
Well, I can't tell you-
To be I'm candid about it, I mean, I think we had seen a flavor of this argument and nobody had briefed it, and we said, we don't really know what to make of that, so go ahead and.
Well, it was a real argument. There was a real self-dealing argument in this case that goes back to the complaint in 2011, and it was about 3 particular corporate transactions. And one of them, the trial court at summary judgment granted summary judgment to Dr. Moon. She said the transaction was fair. She granted summary judgment as to all the other individual defendants because they weren't on the board at the time of that, of any of those transactions. And the court said, this is in the summary judgment order, ended by saying, ordered that count 2 of plaintiff's complaint remains pending as to claims for breach of fiduciary duty arising out of the following alleged self-dealing transactions against defendant Preston Moon. And that identified 2, the real estate deal and the consulting contract. That's a JA 1197. So our point is simply that after Moon 3, that is what was left. And the plaintiffs had acknowledged that that was what was left. The last record citation I'd like to give the court, JA 1326. This is the plaintiff submission after summary judgment. When they were telling the court what's left and what to do next, the court said, the plaintiff said, let's have a hearing on remedies for the claims we won. And then they dropped a footnote. A few count 2 self-dealing claims against Preston Moon remain in the case. And then they said, oh, but those are comparatively minor and unlikely to be tried. So they relegated them to a footnote because they were a footnote and they were always a footnote. Now, to the extent the court is asking, well, maybe the claims that that Moon 3 dismissed on First Amendment grounds, maybe there was some way for them to reopen that and say, well, everything we said before still holds, but we're going to call it fraud, and now we're going to reach a different conclusion. I don't think that works either. First of all, I don't think that is the right way to read the mandate. I'm not going to tell the court what it had in mind. It's certainly not how we read it or how Judge Irving read it. Number 2, if that was the theory, I think they would have had to have raised this fraud exception at some point in the first 12 years of the case, because this was the issue in front of the court in Moon 3. Is this justiciable? And they said no, because there are no religious questions here. They didn't say insincerity. They didn't say it's a smokescreen. They said no religious questions at all. This court saw through that and rejected it, and that was the end of it as far as we're concerned on those claims. Now, I'll also just say, I heard of some flavor in plaintiff's argument of, oh, well, this whole religious thing, this is all a hoax. You kind of look behind it because they don't really mean it. I just want to make clear, not only is that false, it is contrary to their positions over the first 10 years of this litigation. They never claimed that the schism was fake. In fact, their argument was the opposite. Their argument was Dr. Moon and these directors are so committed to his school of thought on the way the church should be that they cannot be trusted to run the corporation because they are on the wrong side of the schism. I would point the court to JA 3031, which was their argument in the closing of the remedies trial, where they said, Dr. Moon, quote, comes to believe he is actually, in fact, the leader of the church. Their proposed findings of fact after the remedies hearing at JA 2277 and 2309, Dr. Moon, quote, believed he was leading the Unification Church movement And the other directors, quote, believe that Reverend Moon selected Preston Moon to be the spiritual heir in the fourth Adam. Those were their proposed findings of fact. And now they're coming to the court and saying, oh, this is all a fake narrative. That is completely the opposite of the truth. And it's a 180-degree change from the positions they espoused for the first decade. I don't think the court should indulge that. Judge Irving certainly didn't. For all those reasons, I mean, I think, hope I'm making clear, I think the fraud exception is really a bit of a red herring as to these claims, because as to what was really left after Moon 3, they weren't dismissed on abstention grounds. It was those two corporate transactions, and the court said you no longer have standing to pursue those under Hooker because they're not extraordinary. I mean, one of them is the sale of the Rockley building in New Jersey by a UCI purchase by a UCI subsidiary of a building in New Jersey that they use for their seafood business. And the plaintiff said, you paid $5.9 million, it was really worth $5.8 million. Okay, so we're talking about $100,000 delta in the value of a real estate building in New Jersey. I can't think of a better illustration of what Hooker said would be wasteful to allow all sorts of putative potential beneficiaries to come into court and challenge routine corporate acts that would waste corporate charitable assets. That's exactly what has happened in this case. Last thing I'll say, absent questions, on this dismissal with or without prejudice issue that plaintiffs raised, the dismissal was properly with prejudice because the Hooker rule, the general rule, the traditional rule that Hooker described is a rule of prudential standing. It's a policy-based rule that we should only have the Attorney General come in to raise these claims because of the risk of waste and duplicative litigation from allowing every potential beneficiary to come into court. Special interest standing is an exception to that general rule. So if you don't satisfy the exception, you lack prudential standing. And that's why the dismissal is properly without prejudice, with prejudice. It also has nothing to do with amending the complaint. They're conflating with or without prejudice with the right to amend, which are, as this court said, are different things. And Judge Irving properly denied any request to amend the complaint, although they never formally moved to amend the complaint at all, let alone said what they would put in the amended complaint. But he recognized it's too late. It would be prejudicial if you want to reopen discovery, years after it's closed and 15 years into this litigation. And it would be futile anyway for the reasons that Judge Shanker that I laid out earlier. There's simply no evidence, and they haven't pointed to any evidence that there was any actual self-dealing in connection with these transactions. If the court has no further questions, we would ask the court to affirm and put an end to this case.
Thank you, counsel. We will now give you a few minutes for rebuttal.
Save the clock's resetting. Thank you. Let me start with where my colleague ended up. The dismissal with prejudice. Prudential standing was never raised by Preston Moon below, nor did they defend it in their briefs on appeal. The issue should be deemed abandoned.
No, I mean, standing is something that courts will raise on their own, whether it's Article 3 jurisdictional standing or prudential standing. Courts should make sure they have proper parties in front of them. It's usually not the type of, I mean, you definitely can't waive Article 3 standing. That's jurisdictional. And I think your position in this case has to be that this was a jurisdictional defect. Otherwise, you wouldn't get to the result of getting a dismissal without prejudice. The whole premise of saying this should be a dismissal without prejudice is that this was a jurisdictional defect. Do you see I mean, there's some disconnect between your argument.
Yes, but I'll move on then to the second piece of it, where the prudential standing analysis by the trial court was wrong. And I think that what counsel just did was conflated prudential standing to cover two Hooker factors. Actually, it's satisfied by the first Hooker factor. So the first Hooker factor looks at the issue of whether the plaintiffs share some criteria beyond being potential beneficiaries that set them apart from the general public. And the concern in prudential standing is almost synonymous. Whether the party is raising another person's legal rights or attempting to litigate generalized grievances. So if you satisfy Hooker factor number 1, you've already satisfied all prudential standing considerations. And the trial court on remand found that we satisfied Hooker factor number 1, as did this court in Moon 1. So the Hooker factor number 1 is synonymous with prudential standing. There's no prudential standing problem. The issue then becomes Hooker factor number 2. Is KIF written out of the case by the Moon 3 opinion? No, it wasn't written out of the case. And the error is in the trial court finding that KIF was read out of the complaint for purposes of self-dealing. And that is wrong because in Miller McGee, it contravenes Miller McGee. And we had Judge Mott in the preliminary injunction ruling. He has a footnote where he acknowledges that the KIF transaction emerged and became central to the case. And he reads it into count 2. At that point, he's dealing with the one subpart of breach of fiduciary duty on duty of loyalty, but he doesn't limit it to duty of loyalty. He reads it into count 2 generally, and then Judge Cordero does the same thing. So we actually have more, and then on top of that, the court enters a $500 million judgment in our favor on a theory that's not even in the complaint.
But you alleged 3 specific transactions as involving self-dealing, as that term is used as a term of art, meaning parties on a single party on both sides of the transaction, at least generally speaking. And you never alleged that as to the donations to KIF and GPF.
Well, we never amended the complaint, and I don't think that the council at the time thought that we needed to, because Judge Mott read the KIF transactions into the complaint for purposes of the other prongs of count 2. So it doesn't really make any sense to say the KIF transaction is in the case as to one theory of breach of fiduciary duty, but not another. It's misleading. And under the Miller McGee case, it would be fundamentally unfair to read it in for one part and not for another. And so at a minimum, we should have had the dismissal without prejudice so we could amend to cure what the court found was a deficiency for Hooker factor number 2. I don't think we have that deficiency because KIF is in the case. The other error that the trial court made on reading KIF out of the case for Hooker factor number 2 was that it presupposes that there is no exception and it doesn't apply. Because if there is an exception and it applies, then KIF is in the case and there was nothing to have to amend. So in sum, I would just like to point out with respect to, I'm sorry, I wanted to also go back to the suggestion that KIF did exactly what Reverend Moon wanted. If we had a fraud inclusion evidentiary hearing to take marginal review of that representation, I mean, we've got counsel here making factual representations about what Reverend Moon wanted. There is tons of evidence that shows that merely building Park 1 is not what they did. Plus, Preston Moon then came out and took credit for Park 1 and said, I might build another one. That speaks to rounds out the self-dealing. And the trial court did find that the allegations, that the remedies hearing evidence resulted in what amounted to self-dealing. So there's some cherry picking of rhetoric from the remedies order, but 2403 JA, the trial court found it appears the money donated to KIF is simply being funneled to the defendants in their own projects. That's self-dealing. We should have had the opportunity to have the trial on self-dealing. And I'll just say the representations that KIF did exactly what Reverend Moon wanted. You haven't heard everything about what happened with KIF. So for example, Preston Moon had an entity that UCI loaned millions of dollars to this associate, Yan Sant. UCI paid off Sant's loan. There's these flow of funds statements showing millions of dollars going right to Preston Moon's entity. And then the indebtedness gets lobbed over as part of the KIF transaction. So KIF becomes a black hole to launder specious loans to associates. I mean, there's a whole story here on fraud inclusion that we should have had the opportunity to make. The representations being made about what happened that are outside the record of this 12B1, 12BC, and factless summary judgment appeal should not be considered and should not be part of this. We should go back. You should order that the fraud inclusion exception exists and either find that it applies on the facts that were already found, secular facts in the trial court below, or remand for an evidentiary hearing on fraud inclusion. Thank you.
Thank you, counsel. The case will be submitted. We'll now call the third case on this morning's calendar, number 24 BG 433, in re Jihan A. Carter.
Feel somewhat abandoned now.
I know. All right, let's hear first from Mr. Reed, counsel for respondent, Ms. Carter.
Morning, Your Honor. May it please the court. My name is McGavick Reed, counsel for Jahan Carter. At my right at counsel table is my law clerk, Thomas Scholter, second-year student at Catholic University. Your Honor, though Ms. Carter filed a pro se brief accepting to several of the board's findings, sorry, I apologize. May I reserve 1 minute for rebuttal?
Sure.
Today we'll only be focusing on the respondent's state of mind when she made the assertions in her small claims claim and on the issue of sanction, which we believe should be a public censure. Turning to the first issue, the record was not sufficient for the board to conclude that the respondent knowingly made misstatements in her small claims complaint. Pursuant to Henry Ukwu, the board failed to properly consider evidence of the respondent's state of mind and of her understanding of the terms dismissed as unsubstantiated when she filed that complaint. It's very important to note that within the context of the disciplinary system, the word dismissed has a very specific connotation, which is different from how a layperson might use it. It means that a complaint is no longer being pursued and that a sanction will not be imposed. To a layperson, it just means that something is not being considered. Given respondent's experience,
Ms. Carter is not a layperson.
Ms. Carter is a lawyer, Your Honor, but the hearing committee noted that she's not a litigator. She doesn't have familiarity with the disciplinary system and her
She
understanding.
doesn't know what the word dismissed means?
It has not within the context of the disciplinary system. So when we take all of the,
I mean, I don't really think of it as having such a special context. I think it means that complaint is over. And unsubstantiated means that nothing's come of it. And when in fact, she's in the midst of negotiating discipline and admitting to some infractions. I find it, frankly, I think the findings below are pretty generous to your client. I mean, it strikes me as being patently false. I mean, I don't understand how any lawyer could understand that to be anything other than a blatant misrepresentation to the court.
so we would point the court to the major discrepancies between the complaint that was filed and the specification that was ultimately charged. You have a complaint that was almost totally not involved with the specification. The complaint had 8 numbered paragraphs, and only some of the language in one of the paragraphs actually made it into the specification of charges. For somebody who has a limited understanding of disciplinary terminology, it might be fair for that person to conclude that since the specification didn't involve most of the complaint, that the complaint itself was not substantiated and that those allegations that were not included in the specification had been dismissed.
Well, I mean, tell me if you think I'm getting this wrong. My rough understanding of the complaint, I mean, I might be getting it wrong in several spots, so feel free to point out each of them. My rough understanding of the disciplinary complaint is, I hired this counsel so she could represent me in California litigation. Due to various misrepresentations, my misunderstandings and misrepresentations to the court in her pro hoc vice application based on where in fact she practiced and representations she made on her website. She was denied pro hoc vice status under threat of sanctions from the court, as I recall vaguely. And which part of that didn't make its way into the specification of charges by disciplinary counsel? I thought that was sort of, I know it goes off into, and also there's some false profiles on her law firm website and she's made up a fake name and attached somebody else's profile to it. I get there's more, But what part of the gestalt of Ms. Collier's complaint did not make its way into the specification of charges?
So, Your Honor, the problem with taking that approach to it is that the board and now, Your Honor, and disciplinary counsel are making inferences from the actual language in the complaint that Collier didn't actually address. In fact, the complaint, I can read to you the pertinent section right now. It was paragraph 5 of the complaint, says only, she, meaning the respondent, was dismissed from case for pro hoc vice due to stating false claims she was able to practice in Los Angeles, in which she stated in the beginning she was in California, made me believe she was able to file the complaint in California and Virginia. That doesn't actually address specific claims about the website. It uses the word false claims, certainly, but it doesn't say what claims were false, why they were false,
But
who they
even
were
if-
directed to.
Sorry, even if one paragraph of Ms. Collier's bar complaint was still sort of pending or had been adopted by the disciplinary council or formed the basis of the investigation, isn't that enough to alone to say that the bar complaint had not been dismissed as unsubstantiated?
It's technically accurate to the extent that the bar complaint had not been dismissed. However, we have to look at the respondent's genuine understanding that since the specification of charges was largely different from the complaint, she did not make the foundational connection between the two. And there is precedent in recent case law where a respondent misreports their disciplinary status because they misunderstood the obligation and the disciplinary system specific parlance. That's the case of Henry Rody, which says, and if you give me one moment, I will read it to you.
Can I just
Sorry.
interject to say this sounds very much like a credibility finding to me? I mean, whether or not sufficient evidence exists based to substantiate that this was false and she knew it to be false. Somebody heard testimony on that, the hearing committee. What did they say about her credibility that she didn't know?
The hearing committee said that they did not believe that she testified falsely. However, they could not credit her testimony. So I would like to just simply read that
Sure,
language
please.
from Rody. Rody stated that, quote, "An honest lawyer may have understood incorrectly in our view that the proceedings before the Court of Appeals ended with the referral order to the board and thus had no reason to disclose." The Rody case is actually precisely on point with this case.
Yeah, I mean, that can't be the test though, counsel. It can't be that somebody could have misunderstood this and therefore the evidence is insufficient to find that they did understand it. I mean, that's just a straight up credibility finding. You could say, well, yeah, somebody could misunderstand this, but based on all the evidence and hearing respondent testify, I think she understood it. That's perfectly within the province of a fact finder like the hearing committee. It can't be that the evidence must foreclose all possibilities other than that she understood for somebody to draw the conclusion that she understood.
It doesn't need to be that, but it needs to include adequate considerations of all evidence. And here the board failed to consider her actual state of mind at the time that she made the representations and her understanding of the words that she used. That's in the case of Henry Ukwu that's been supported several times since that case has been decided. At this point, I would, however, like to turn to the issue of sanction and to note that even if the court is not inclined to disturb the board's finding that she knowingly made a misrepresentation in her small claims complaint, the recommended sanction is outside of the range that's appropriate here. The board cites 3 cases in recommending 60 days: Henry Owens, Henry Rosen 3, and Henry Phillips. Each of those cases involved substantially more egregious misconduct. And in fact, in 2 of those cases, they actually imposed a more lenient sanction than the 60 days that's been recommended here.
In any of those cases, were the charged false statements being used directly against a former client of the council?
They weren't being.
Usually false statement, this is something that has bothered me about this case. Most of these cases, when you're talking about false statements, lawyers sometimes exaggerate their case in an adversarial proceeding in order to advance a client's cause. And that is obviously still an ethical violation if they're being dishonest with the court. There is a flavor of this case that makes it far worse than the cases that I tend to see, which this was not advocacy on behalf of a client where Ms. Carter got over her skis on what she was representing. This was litigation that she affirmatively brought on her own behalf against a former client for her own monetary benefit. And it's in that context that she makes what appeared to me to be obviously knowingly false statements, that she brought unsubstantiated claims that were later dismissed, making it especially egregious. Do you have a reaction to that?
So I do have a reaction to that, Your Honor, and I will say in each of those three cases, they involved affirmative, deliberate, knowing misrepresentations to the court to the benefit of the person making that representation. In Owens, the respondent lied to an administrative law judge about violating a sequestration order. In Phillips, the respondent lied to the court about the status and availability of drug money in a forfeiture case. And in Rosen 3, the respondent lied in 3 separate pleadings and had previously been disciplined for lying once. This case.
I mean, those, again, that strikes me, the first and the third at least strike me as your classic, I've been caught and I'm going to fudge the facts a little bit to get out of trouble. Not the, I'm going to show up to court and be the one to bring the case and make affirmative misrepresentations in order to get money from a former client of mine. I mean, that's still, I'm not, my concerns are not allayed. I mean,
Well, so if I may then suggest that that goes to an issue of materiality. And in each of the cases cited by the board, the misrepresentation had a substantive impact on the proceedings and actually gave the wrongdoer an advantage. Here, no such thing happened. Yes, the case was against a former client, which we know the disciplinary system frowns upon. However, the statement made wasn't actually material to the proceedings. It was made only to show an order of events, and it was made to show the insincerity of the client's issues with paying the bill.
Right, but I mean, you just said what I was gonna say, which is it's suggesting, clearly the suggestion, the implication in your client's statement was that Ms. Collier made something up. And that's really, casting aspersions on a former client that is also false. That just seems aggravating to me.
Well, I would say that the statement was not made for the purpose of casting dispersions on Collier. It was to demonstrate the efforts that she took to not pay her bill. We understand, and today I believe my client would make a very different decision if a client of hers were to not pay their bill. My client is a solo practitioner.
I just want to be very clear. I take no umbrage at your client going after somebody for not paying their bill. It just strikes me as incredibly material to that determination, whether or not your client did her job in the representation. And so when somebody says, I'm not paying my bill, because the whole reason I hired you is to show up in court in California and appear for me. And then you got to California and you filed something and the court nearly sanctioned you because you were saying dishonest things and you couldn't actually represent me in that case. I'm not going to pay you. When you're seeking your attorney's fee for that in a court proceeding, one thing that would be very relevant to the court would be whether or not you provided the services you promised. And one thing that is very relevant to that inquiry is whether or not the other person had a substantiated bar complaint against you for your representation in that case. Because if they did, the chances are they're not going to be stuck with that bill. So I'm still, I mean, like I said, I know, of course, lawyers have the right and really ought to go after clients who aren't paying their bills. The problem here is the misrepresentation seems entirely relevant to whether or not those amounts were actually due.
Your Honor, if I may, I believe that the representation, the terms were different than you recently suggested. My client was hired by Ms. Collier to obtain a monetary recovery from Steve Harvey, not specifically to file a complaint in California. And therein lies the difference. The client did eventually obtain a settlement from Steve Harvey, and the respondent had done valuable work on her case. towards the end, the client came up with this complaint that she couldn't file a complaint in California, therefore everything was worthless. However, that
Well, that's
seems in
then a
itself-
factual dispute that's being resolved in the bar disciplinary process, right? And so what do we make when we're looking at what your client potentially knew or understood, as you were starting to start with, when in her amended affidavit of negotiated discipline, she's saying that she understood that this complaint at the time she made the statement to the court regarding Carter 1 could be appealed, could be challenged, could be overturned at the committee hearing level, et cetera.
Well, that goes to her understanding about the lack of finality at that point in time. We don't dispute that she signed the affidavit. We don't dispute what the affidavit said. However, to answer your question specifically, Your Honor, her understanding of the connection between the complaint and between the specification was incomplete, as somebody who is familiar with the disciplinary system might review it. And again, the issue of materiality is necessary. The misrepresentation that she made didn't actually serve to benefit her in any way. It was made solely to describe the progression of events. And ultimately, the complaint was withdrawn from the small claims court before it had a chance to impact anything. This
Do
makes
we
it-
know that? When
We
you
do know
say
that.
we don't know that there was a settlement or the bill was paid?
There was no settlement and the bill was, I don't believe that's part of the record,
Right,
Your
that's-
Honor, but I can stipulate to that.
Fair enough.
But in any event, Your Honor, considering the similarities between that case, I see my time has expired. May I?
Please finish the thought.
And the similarities between the Rhodey case where a public censure was issued, the court should adopt the precedent and should impose a public censure if it is inclined to impose a sanction at all. Thank you.
Sorry, Mr. Reed, can I ask you one quick question?
Yes.
You started by talking about state of mind and lack of knowledge on the part of your client. How would that pertain to 8.4, which only requires reckless conduct?
So it was not made, that information was not given in precise, context of 8.4. It was to demonstrate their lack of understanding. Well, I guess it can be applied to 8.4 as well. But we would assert that the misstatement was negligent as opposed to reckless because of her lack of understanding. It wasn't made with conscious disregard to the information that was available and to what she didn't know. She had a genuine understanding that the word dismissed and the word substantiated were appropriately used in that context.
Thank you, counsel.
Thank you.
We'll now hear from disciplinary counsel. Mr. Metzler.
May it please the court, Jack Metzler for the Office of Disciplinary Counsel. Just a couple of points that in response to my friend's argument. With regard first to Ms. Carter's state of mind, it's not, I think the argument was that the hearing committee and the board didn't consider that, and that's wrong. They made specific findings about her state of mind. They said that she knew that the complaint was not dismissed.
Well, I mean,
which
how does,
said the opposite.
I think the board's statement is very confusing to me. I mean, the court said it was not finding that she made an intentionally false statement, but it didn't credit her answer and that she had engaged in a post hoc rationalization, which I think by its definition means that she made it up, in which case she did intentionally make a false statement to the hearing committee.
I agree with you, Judge Tinker.
But we don't have a credibility, we don't have an adverse credibility finding.
Well, I think, well, I think you do have I think when you say we can't credit it because it's a post hoc rationalization, that's the equivalent of saying, look, we don't believe it. She may believe it. Maybe she was sitting on the stand and convinced herself. And so
It's
in that
a
moment-
self-delusion kind of finding that,
I mean,
well,
it's, it's a reference to George Costanza, I think, which is, it's not a lie if you believe it. Is that what you
I
think?
think I told the court that very line about a month ago. But yes, that's exactly right. So and hearing committees are often reluctant to make a finding that someone intentionally lied on the stand because it's significantly increases the sanction. And so I think the hearing committee, did the best the best it could, but I do think it amounts to a credibility finding in that her testimony, that her state of mind was she didn't understand. She really thought this was dismissed. She thought it was, she thought that none of the words, I think she said in her board brief, none of the allegations made it into the complaint. I mean, that itself is false, as her counsel acknowledges today.
Let me see if I have this right. Your reading of what the board is saying is when she filed the second complaint, she understood what she was saying was false. But before us, she's testifying forthrightly because she's sort of deluded herself into believing it in the aftermath of it. Is that roughly how you read it? I mean, I confess some confusion about this part.
Yeah,
as
I
well,
think it's
so-
confusing, and I think the court's right to be confused because they don't add up together exactly. I would say that there is not an express finding that she was lying, and there nor is there, but there is, I think, a finding that that these were post hoc rationalizations. They were something that she came up with afterward, and so maybe the board and the hearing committee didn't want to go so far as to say there was clear and convincing evidence that she was lying on the stand, and so they decided not to make any actual finding about that. But I think your interpretation is certainly consistent. But stepping back, regardless of how you look at that particular part of it, the statement was made against a client. It was, as Your Honor says, knowingly, clearly false, and obviously so. Her claim that she didn't believe it was not credited by the court, by the board, or the hearing committee, and those are, I think that amounts to a credibility finding that you would, can affect the ultimate question of fact under the Crane case. And I'd just like to say, oh wow, I thought I had 1 minute left. I have 11 minutes left.
You don't need to use all of it, Mr. Missler.
And I won't. The only other thing I would add is with regard to the sanction argument, I would just point out that this is a very serious dishonesty. It is started with dishonesty to a court. She then lied to disciplinary counsel about that dishonesty, and then that became the part of negotiated discipline. So she has dishonesty on dishonesty, and she was sanctioned for that. And then she goes to another court and lies again about her lying about the lying. And so it's a pattern emerges, and it appears that Ms. Carter has a problem telling the truth, and to do so to courts. And it's important in this context, not just because it's against a client, but it was in small claims court where, on the face of her complaint, she's saying, I'm a lawyer, and the courts know, the judges are very busy in that court, and litigants often appear without counsel. And so the special responsibility of an attorney to be forthright and truthful to the court has even that much greater importance, because the court is likely to believe her when she says that.
What sanction did you request before the hearing committee?
I think we asked for 1 year.
And now it's down to 60 days, but you don't take any exception to that or ask for more than that. I mean, in light of everything that you've just said, I mean, somebody in the midst of another disciplinary proceeding, really wrapping one up, to file something like this against the client, strikes me as pretty outrageous. It does not seem to fit within the 60-day cases that I've seen, but we provide a lot of deference to the board's recommendations, and probably more so if you're not asking us to do anything but impose them. So,
well, I would say the court also has said very often that the ultimate sanction rests in the hands of the court, not the board, and the court certainly has changed the sanction recommended by the board where it thinks it might foster a tendency towards inconsistent dispositions for the same conduct. And I agree with you. In fact, I would point out that the 60 days recommended by the board is actually less than Ms. Carter, the net suspension she had in the negotiated discipline, which was 6 months with all but 90 days stayed. So she actually would be getting off lighter than she did the last time. But as you say, this is not something we took an exception on. So I won't go further than that. If there are no other questions, then we're happy to rest on our brief.
Thank you, counsel. Mr. Reed will give you a few minutes for rebuttal.
I don't think that'll need that many minutes. This is going to be relatively brief. At the end of the day, the board, the hearing committee, and disciplinary council ignored the Rhodey case, which is precisely on point, and the court should not ignore it. Both of these cases involved a misrepresentation about the status of a pending disciplinary complaint. Rhodey specifically and falsely, with knowledge, certified to the Eastern District of Virginia that he was not the subject of disciplinary charges and had not been reprimanded by a court based on his conduct that reflected on his fitness to practice law. Yet in that case, in 2020, the board still found that the appropriate sanction in those circumstances was a public censure.
I'll read Rhodey, so I'll confess I haven't yet. Was that one of the standard, you sign a piece of paper for entering another bar or, appearing in a case saying I'm not currently under investigation for disciplinary?
I believe it was the standard
Uh-huh.
form for the Eastern District. However, if you read the facts of that case, a lot of analysis went into it. Rhodey actually believed that he couldn't sign that paper. He had a discussion with a member of his firm and then ultimately concluded that since the hearing committee was not a court and since the pending discipline hadn't yet been approved, that he had no disclosure obligations, and he deliberately withheld that information from the attorney who sponsored him. That attorney later on testified that she would not have sponsored him and he would not have gained admission to the Eastern District had he been truthful in his certification and had he raised that to the court. Even considering that he benefited from his deliberate submission of incorrect information, the board still reasoned that the appropriate sanction was a public censure. Therefore, Your Honors, we would ask that if the court is inclined to impose any sanction, that the court should consider Rhodey, which is precisely on point and encompasses the exact same violations, that the only appropriate sanction here is a public censure. If there are no further questions, then we rest.
Thank you, counsel. The case will be submitted and the court stands adjourned.